Hello, good morning, good afternoon, good evening, everyone. So we're done with the formation and organization of corporations. We're done with the basic principles of corporation. We're done with the board of directors or trustees and the corporate officers. Now we move on to the powers of corporations. So, just a little reminder. Uh, for our previous discussions, we have already uh, tackled about how the corporation exercises its power. So, the corporation exercises its power through its board of directors or trustees, or it can be the corporate officers, except when the corporation code requires the approval of stockholders. So, all throughout this topic, since the topic is all about the powers of the corporation, should always take note that the corporation always acts through its BODs, BOTs, or the corporate officers. So yun lagi throughout this discussion. And of course, take note also that the powers of the corporations are limited to what is conferred by law, which is the revised corporation code. So dun lang siya. And then those that are implied or incidental to its existence or necessary to accomplish its purpose. So yun yung you should always take note during this discussion para meron kayong guiding principle. Okay? So first, corporate powers and capacity. Number one, to sue and be sued in its corporate name. So we all know that the corporation is a separate juridical entity from its stockholders, board of directors, and corporate officers. Hence, the corporation can be sued. The corporation can sue in its own corporate name. Okay, and you have to relate that with derivative suit. As we have discussed last meeting under board of directors or board of trustees, when there are decisions of the board of directors or the corporate officers that is prejudicial to the corporation, okay, any stockholder or stockholders may sue in behalf of the corporation. So ang totoong nagsusu dun is the corporation, okay? It is only the stockholder that is filing the case against the board of directors or the corporate officers. So there's nothing really new under this power. So natural kung tao, whether natural or juridical, it can sue and it can be sued. Okay? Number two, to have perpetual existence unless the certificate of incorporation provide otherwise. Of course, if it provides for a perpetual existence, it will exist perpetually, even if the incorporators are already long dead. Okay? It can also put, the corporation can also put a term of existence of 20 years, 30 years, 40 years, depending on their intention. But it can exist perpetually. Okay? The third, corporate power and capacity is to adopt and use a corporation seal. Okay? Which they use through their board resolutions. To amend its articles of incorporation in accordance with the provisions of this code. Okay? Of course, the corporation can make changes in its articles of incorporations, di ba? And you can do that through the decision of the board of directors or trustees, which is later on ratified by the stockholders. Okay? Number five, of course, if you can amend the articles of incorporation, you can also adopt the bylaws that are not contrary to law, morals, or public policy, and to amend or repeal the said bylaws, of course. And then, number 6, in case of stock corporations, to issue or sell stocks. Of course, they are stock corporation. What do? They issue and sell stocks and to sell treasury stocks in accordance with the provisions of this code. And if you're a non-stock corporation, you don't have any stock, what do? You admit members. So one of their powers is to admit members of the corporation. 7. To purchase, receive, take or grant, hold, convey, sell, lease, pledge, mortgage, and otherwise deal with such real and personal property, including securities and bonds of other corporations, as the transaction of the lawful business of the corporation may reasonably and necessarily require, subject to the limitations prescribed by the law and the Constitution. Meaning, just like an ordinary person, the corporation, being a juridical person, can purchase properties, real or personal, can receive, can take, can grant, can sell, can lease, can mortgage properties. Okay? Just like an ordinary natural person. Number 8, to enter into a partnership, joint venture, merger, consolidation, or any other commercial agreement with natural and juridical persons. So, this answers our questions before regarding whether or not a partnership can enter into another partnership, or a corporation can enter into a partnership. Diba? Why? Because they are essentially persons. Diba? Juridical person. So, they can enter. Sir, paano yan? Ang dami nila. Lahat sila magiging partner. Hindi. Okay? Siyempre, the corporation is represented by, kung sinabi nilang si President yung mag-represent, okay. Then, si President lang yung mag-act in behalf of the corporation. But, all decisions na gagawin ni President should be decided by the Board of Directors. Diba? So, ganun yan. Number 9, to make reasonable donations, including those for the public welfare or for hospital, charitable, cultural, scientific, civic, or similar purposes. Just like a normal person, again, natural person, diba? You can make reasonable donations. Okay, but there's a limitation with regards to foreign corporation. Okay, foreign corporation. A foreign corporation shall not or is not allowed to give donations in aid of a political party or candidate or for purposes of partisan political activity. Okay? Of course, to protect the nation from possible control of other countries, diba? If you allow that to happen, and a person is funded by a foreign corporation, diba? Once that person is elected, he has powers that may be exercised unlawfully. So that's why it's there to protect the country. So yun. Number 10, to establish pension, retirement, and other plans for the benefit of directors, trustees, officers, and employees, of course. Diba? Those are statutory rights under labor law. Okay? Because it covers the employees. To exercise such other powers as may be essential or necessary to carry out its purpose or purposes as stated in the Articles of Incorporation. So dito mo i-relate ngayon yung implied or dito mo i-relate yung implied powers ng corporation. Ibig sabihin, even if it is not stated in the corporation code or in the articles of incorporation and bylaws, okay, as long as it is implied and is necessary to achieve its purpose, that is a valid exercise of a power of a corporation. Okay? Another power, a power to extend or shorten corporate term. We have discussed a while ago that the existence of a corporation is perpetual unless otherwise stated. So, if they decided that the corporation shall exist for 20 or 30 years, then so be it. But they can also extend or shorten the corporate term. How? Number one, by the approval of a majority, both of the board of directors or trustees. Okay? Majority vote. Number two, after ma-approve ng board of directors or trustees, kailangan i-ratify yan ng stockholders holding 2/3 of the outstanding capital stock or of its members. Okay? So, approved by majority of the board of directors and ratified at the meeting by the stockholders representing at least 2/3 of the outstanding capital stock or the members if it is a non-stock corporation. So, if the corporation decided that they will exist for only 20 years and then later on they decided to extend or to shorten their corporate term, sabihin mo nasa 15th year na sila, tapos gusto pa nilang extend ng 30 years, ito yung kailangan nilang gawin. Approval by a majority of the board of directors and then ratification by the stockholders or members representing at least 2/3 of the outstanding capital stock or the members. How? Sabi natin kanina, it must be ratified in a meeting by the stockholders. So, paano mo i-start yung meeting na yon? Through a written notice. Okay? Written notice sent to all stockholders or members. Ano yung nandun sa written notice? Yung proposed action. Ano yung proposed action natin? To extend or shorten the corporate term. Okay? Then of course, since meeting yun, the time and the place. Okay? Saan mo isa-send yung written notice? Sa residence nung stockholders or members. Paano? Either by registered mail, personal service, or by email. Allowed na ngayon ang email if allowed in the bylaws and with consent of the stockholders. So, hindi basta-basta magsisend ka sa electronic mail or electronically. Okay? But, if you are going to send via registered mail, okay lang. Kung send mo yung written notice personally, mas okay. Kung email, kailangan nandun sa bylaws. And kailangan may consent din yung stockholders para kahit masend, ang purpose kasi niyan, para kapag sinend mo yung written notice sa email, kahit hindi niya mabuksan yung electronic mail, there's already presumed parang knowledge on the part of that stockholder since he allowed that it can be sent through email, whether mabasa niya yun or hindi, that tantamounts to knowledge. Okay, kaya kailangan ng consent bago i-send through email. Especially now, since everything is moving digitally. So, minsan hindi na sinesend sa through mail, minsan ano na talaga, email na lang. So, it's important to know that it must be stated in the bylaws and with consent before you send it through email. In case of extension of corporate term, a dissenting stockholder may exercise the right of appraisal under the conditions provided in this code. Okay? Diba nandito tayo sa power to extend or shorten the corporate term. Sinabi niya, dissenting stockholder, ibig sabihin, hindi siya agree na i-extend yung corporate term. Kumbaga, ang purpose niya is i-extend yung corporate term, yung stockholder na ito, ayaw niya. Ayaw niyang i-extend, kumbaga gusto niyang mag-end na. Okay? He may exercise his right of appraisal. What is right of appraisal or appraisal right? Appraisal right is when is a right of a stockholder who dissented and voted against the proposed corporate action, di ba? Yung sabi natin, extension yung proposed action pero nag-dissent siya or ayaw niya. May choose to get out of a corporation by demanding payment of the fair market value of his shares. Kumbaga, ganito lang yan. Since ayaw mo na ma-extend yung term ng corporation, ibig sabihin, ayaw mo na maging stockholder, di ba? Ibenta mo na lang yung right mo, ibenta mo na lang yung shares mo, di ba? Para at least sila na gustong ma-extend yung term ng corporation, itutuloy nila yung corporation. Ikaw na ayaw mo, ibenta mo na para makuha mo na yung shares mo, sila na lang magtutuloy. Yun yung appraisal right. Okay? You can as a stockholder or as a stockholder, you can always exercise your appraisal right basta meron kang vote or dissenting opinion with regards to the decision of the board of directors. You can always exercise your appraisal right, meaning you can always sell your shares. Diba? Para labas ka na sa corporation since hindi naman na parehas yung goal mo dun sa goal ng corporation. That is your appraisal right. Power to increase or decrease capital stock, incur, create, or increase bonded indebtedness. Okay? Paano ito na-exercise? Of course, just like dun sa power to extend and shorten the term, dapat approved by the majority vote of the board of directors and 2/3 and ratified by the stockholders representing at least 2/3 of the outstanding capital stock. Okay? Yan yung lagi nyong tatandaan. Approved by a majority vote of the board of directors and represented by at least 2/3 of the capital stock kapag mag-i-increase or decrease ka ng capital stock. Okay? Of course, if you are a non-stock corporation, hindi mo pwedeng exercise. Why? Wala ka namang capital stock, di ba? Non-stock corporation ka nga. So, hindi niya pwedeng exercise. Ang exercise niya dyan, itong isa, yung incur, create, or increase bonded indebtedness. Okay? Paano na naman? Kasi nga, meron na namang ratification ng shareholders. So, the same procedure, written notice stating that the proposed action, the time and place of the meeting shall be sent to the stockholders' place of residence through registered mail, personal service, or by email, provided that the stockholders give their consent and it is in the bylaws. So, same siya dun sa kanina. Tandaan nyo, lagi itong mag-occur if there is a ratification required. Yan. If merong ratification required by the stockholders. Why? Because laging magkakaroon ng meeting pag ganyan. And bago ng meeting, there should be a notice sent to the stockholders. Why? Para bumoto sila dun sa action na yan. Ngayon, kapag decide yung board of directors and yung stockholders, yan, there must be a certificate signed by majority of directors, countersigned by the chairperson and secretary of stockholders meeting. So, hindi na lahat ng stockholders. Yung chairperson and secretary of stockholders meeting lang. Okay? Ano yung laman ng certificate? That the requirements of this section have been complied with, requirements of the law. That the amount of the increase or decrease of the capital stock, if yung concern nyo is yung increase or decrease of the capital stock, of course, you provide there the amount. Diba? Gaya ng, if in case of increase in the capital stock, ito lagay mo, the amount of the capital stock, the number of shares, kung par yan, kung no par, lagay mo pa rin, the names, the nationalities, and addresses of the person subscribing to that increase in the capital stock, the amount of capital stock, or kung no par yan, number of no par stock, the amount paid by each on the subscription in cash or property, or the amount of capital stock or number of shares of no par stock allotted to each stockholder. Okay? Kung ang purpose naman is to incur or increase bonded indebtedness, of course, ilalagay mo din dyan, di ba? The amount of stock represented at the meeting, di ba? Kailangan at least 2/3 of the capital stock. The vote, dapat yun yung vote. The vote authorizing the increase or decrease of the capital stock or the incurring, creating, or increasing of any bonded indebtedness. Yan lahat dapat nandun sa certificate na kailangang signan ng directors, countersigned by the chairperson and secretary of the stockholders meeting. Okay? After that, what happens? After voting, it must be approved by the SEC, so the Securities and Exchange Commission, and when proper, it must also be approved by the PCC or the Philippine Competition Commission. Okay? The application with the SEC shall be made within 6 months from the date of approval of the Board of Directors and stockholders, which period may be extended for justifiable reasons. So, yun. Dapat, kapag na-approve na ng Board of Directors at stockholders, meron na yung certificate na sinabi natin kanina, it must be applied to the SEC within 6 months from the date of approval. So, kapag na-approve na, dapat kaagad na ma-forward sa SEC. Okay? After that, after mo nag-apply sa SEC or after mo na-forward yung certificate sa SEC, the SEC will either approve or reject it, di ba? If in-approve yan ng SEC, paano malaman if na-approve yan ng SEC? If the certificate of filing is issued by the SEC, then it is deemed approved. Ibig sabihin, you can already increase or decrease your capital stock or incur or create or increase your bonded indebtedness. Okay? Provided that the SEC shall not accept for filing any certificate of increase of capital stock unless, okay, if what your action is to increase the capital stock, dapat merong sworn statement yung treasurer ng corporation. Okay? Tandaan, ito ina-apply lang if increase of capital stock ang action nyo. Kung increase of capital stock, dapat may sworn statement si treasurer. Ano yung sworn statement ni treasurer? That at least 25% of the increase in capital stock has been subscribed. Ibig sabihin, yung pinropose nyo na increase sa capital stock, dapat 25% nun na subscribe. And that at least 25% of the amount subscribed has been paid in actual cash to the corporation, or if not cash, property, the valuation of which is equal to 25% of the subscription has been transferred to the corporation. So, take note, recap, if your proposed action is to increase the capital stock, there must be a sworn statement provided by the treasurer stating that at least 25% of the increase in the capital stock has been subscribed. And that 25% of the amount subscribed is actually paid, whether in cash or in kind or in property. Okay? Provided further that no decrease in capital stock shall be approved by the SEC if its effect shall prejudice the right of corporate creditors. Precisely, di ba? If kanina yung decision is to increase capital stock, ngayon naman if decrease. Given merong power ang corporation na mag-decrease ng capital stock, but the corporation cannot decrease its capital stock to the point that it will prejudice the right of the corporate creditors. Meaning, hindi niya pwedeng bawasan yung capital stock niya to the point na wala nang masisingil yung corporate creditors later on. So kapag gano'n ang ginawa ni corporation, hindi pwede at malamang sa malamang hindi ma-approve ang kanyang decrease in capital stock. Okay? Non-stock corporations may incur, create, or increase banded indebtedness precisely because they are non-stock. Hindi naman sila pwedeng mag-increase or decrease ng capital stock kasi non-stock sila. Ang pwede lang gawin, incur, create, or increase their utang, banded indebtedness. As long as it is approved by majority of the members. Okay? By the majority of the Board of Trustees and ratified by 2/3 of the members. Okay? Duly called for the purpose. Since yan, mayroon na namang ratification, you always apply yung written notice rule. Okay? Bonds issued by a corporation shall be registered with the SEC. Take note. Which shall have the authority to determine the sufficiency of the terms thereof. That's why registering as a corporation is is hard compared to being a sole proprietorship or to being a partnership, because every action there is a government regulating body that monitors or that determines your decision. Gaya nito, i-increase mo gusto mong mag-issue ng bonds, 'di ba? Para merong kang pondo, yung corporation. Yung bonds na yun, kailangan mo pang i-register sa SEC, 'di ba? And SEC will first determine whether sufficient yung terms ng bonds, 'di ba? Hindi basta-basta. Unlike if you are a sole proprietorship or partnership, 'di ba? Ang iisipin mo lang naman doon is your loans with the bank, your loans with the financing institutions. Unlike here, merong government regulations na you have to comply. Every action you have to do, you have to comply. And every action, there should be board resolution in order for the corporate power or the corporate act to be valid, di ba? Tapos na tayo din sa power to extend, power to shorten. Ito naman tapos na rin sa power to increase, decrease capital stock, power to increase indebtedness. Ito, power to deny preemptive right. So there are two things that you have to know here. First, preemptive right. Ano yung preemptive right? Preemptive right is the right of stockholders in a stock corporation to subscribe to all issues or disposition of shares of any class in proportion to their respective shareholdings. Doon muna tayo. Preemptive right. Meaning that all issues of shares or disposition of shares made by the corporation must be first offered to the stockholders. Dapat meron silang right na sila muna ang subscribe dun sa shares na i-issue ni corporation. Why? Because in order to protect or to retain proportionate control. Diba? Hindi naman yung lahat isusubscribe nila, hindi. Kasi kapag nag-increase ng issuance ng shares or disposition of shares yung corporation, of course, maapektuhan yung shareholdings ng isang shareholder. Diba? Let's say for example, before nag-issue ng share si corporation, 20% ang hawak ko, for example. 20% of the shareholdings is mine. Kapag nag-issue yan ng bagong shares, mabawasan yung percentage ng shareholdings ko. Okay? So, dyan pumapasok yung preemptive right. Para ma-maintain or ma-retain ko yung previous shareholdings ko na 20%, I am allowed or I have the right to subscribe to a certain percentage of yung bagong i-issue na share para ma-retain ko yung 20% na shareholdings ko. Yun yung preemptive right. Okay? Ano naman yung power to deny preemptive right? Okay? So, yung preemptive right, nandyan na yan. Kailan siya hindi pwedeng ma-exercise ni stockholder? Okay? Number 1, when that right is denied by the Articles of Incorporation or in an amendment thereto. Yun yung una. Okay? Basta provided sa Articles of Incorporation or in an amendment thereto na pwedeng i-deny yung preemptive right ni stockholders, pwede. Okay? Number 2, when there are shares issued in compliance with laws requiring stock offerings or minimum stock ownership by the public. Okay, hindi pwedeng exercise yung preemptive right. Number 3, when the shares are issued in good faith with the approval of the stockholders or representing 2/3 of the capital stock in exchange for property needed for corporate purposes or in payment of a previously contracted debt. Meaning that shares are only issued, okay, to meet the needs of the corporation or to pay a previously contracted debt. Hindi mo pwedeng exercise yung preemptive right mo. Why? Because makikita mo sa nature nung number 3 that shares are issued by the corporation because they need funds. Okay? They need liquidation. They need liquid assets. Okay? Kaya mag-issue ng shares. Okay? Take note also that preemptive right is recognized only with respect to new issues of shares and not with respect to additional issues of originally authorized shares. Diba? Matatandaan nyo nung previous topics natin, there's what we call the authorized capital stock. Makikita mo dun kung how much is the authorized capital stock. Okay? Hindi lahat ng authorized capital stock kasi may issue kaagad. So, pwedeng 80%, ganun lang dun ang may issue agad. Kapag yung in-issue na share ni corporation is galing dun sa authorized capital stock, hindi mo pwedeng exercise si preemptive right. Because it is already authorized. Okay? Kasama na siya dun sa issuance. Hindi pa lang, kasama na siya dun sa authorized shares. Hindi lang siya na-issue. Okay? But if yung shares na i-issue is aside from those originally authorized, okay, then dun mo pwedeng exercise yung preemptive right ng stockholder. Okay? So take note, any shares issued by the corporation, the stockholder has a preemptive right, meaning they have the right to subscribe to it first before na-issue sa labas. Unless it is provided in the Articles of Incorporation that it can be denied. Or that the shares are issued in compliance with the laws requiring stock offerings or minimum stock ownership by the public. Meaning kasi, kailangan ma-meet yung minimum stock ownership by the public. Meaning, talagang sa labas siya i-issue. Hindi sa original stockholders. Okay? Or third, when the shares are issued for corporate purposes or to pay a previously contracted debt. Okay? So, yun yung tatandaan nyo under preemptive right and the power to deny preemptive right by the corporation. Let's go to the sale. Of course, the corporation can sell, can dispose, can mortgage, can pledge its own property, di ba? Kasi yung corporation is a separate juridical entity. Okay? A corporation may, by a majority vote of its board of directors or trustees, sell, lease, exchange, mortgage, pledge, or otherwise dispose of its property and assets upon such terms and conditions and for such consideration, which may be money, stocks, bonds, or other instruments for the payments of money or other property or consideration as its BOD or BOT may deem expedient. Okay? Meaning, hindi kailangan ng ratification ng stockholders. Okay? The corporation, through the board of directors alone, can sell or dispose their assets. Ngayon, kailan kailangan yung ratification ng stockholders dito? When the sale is the sale of all, meaning lahat ng properties, or substantially all of the corporation properties and assets, including its goodwill, dapat meron ng ratification ng stockholders in a meeting representing at least 2/3 of the outstanding capital stock, or kung non-stock corporation siya, 2/3 ng members. Okay? So kung isang property lang, okay, hindi na kailangan ng ratification ng board ng stockholders. Pero kung ang sale is all or substantially all, there must be ratification of the stockholders representing at least 2/3 vote of the outstanding capital or 2/3 of the members. What if dun sa non-stock corporation, okay, walang member na may voting right, so lahat sila walang voting right, lahat lang sila member lang, walang right to vote. Okay? The vote of at least a majority of the trustees in the office will be sufficient. Okay? Since in that non-stock corporation, the members don't have voting rights, okay, then it shall be the majority of the decision of the board of trustees that will suffice in order to sell all or substantially all the assets of a corporation. Okay? Tandaan yan, kapag yung members is walang voting rights, ang magde-decide is board of trustees. Pero kung merong voting rights, mag-a-approve yung board of directors ratified by members na may voting rights. The determination of whether or not the sale involves all. Yan. Paano mo malaman, sir, if yung sale is involving all or substantially all of the properties of the corporation? Of course, you have to compute the net asset value. Okay, yun yung basis mo. Yun yung primary basis mo. Okay? Sir, paano kung hindi mo makita kung na-compute mo yung net asset value but it is insufficient as to determine whether substantially all yung properties ang nabenta? Okay? Ito naman yung next. If thereby, the corporation would be rendered incapable of continuing the business or accomplishing the purpose for which it was incorporated. Okay? Considered as all or substantially all of the corporation properties yan, basta after ng sale, the corporation would be incapable of continuing the business or accomplishing the purpose for which it was incorporated, precisely because baka binenta mo na yung business kasi ng corporation. Diba? Doon mo ma-determine na lahat na pala nabenta na. Okay? In that instance, there must be an approval of the board of directors or trustees ratified by the vote of 2/3 of the outstanding capital of the stockholders or 2/3 of the members. Okay? Since merong ratification in both instances, okay, since merong ratification ng stockholders, mag-a-apply pa rin yung written notice rule, di ba? Paulit-ulit. Written notice states your proposed action, time and place of meeting, sent to the stockholders or members in their place of residence via registered mail, personal service, or electronic mail if allowed in the bylaws, and consent by the stockholders. Any dissenting stockholder may exercise the right of appraisal, di ba? Meaning, they can sell their shares at fair market value. Why? Because you're basically selling all or substantially all the properties and ayaw mo mag-agree, di ba? If ayaw nang ituloy ng corporation, gusto na nilang ibenta sa ibang corporation at ayaw mo, ibenta mo na lang yung share mo para mabenta na nila sa ibang corporation, di ba? Yun lang naman yun. Kaya allowed ka mag-exercise ng appraisal right. After such authorization or approval by the stockholders or members, the BODs or BOTs, nevertheless, in its discretion, abandon such sale, lease, exchange, mortgage, pledge, or other disposition of property and assets subject to the rights of third parties under any contract relating thereto without further action or approval by the stockholders or members. Okay, this one gives power to the BODs or BOTs that even if the proposed action is authorized or approved by the stockholders or members, okay, the BODs and the BOTs in its discretion can abandon the decision. Kung ibebenta, mortgage yung all or substantially all, pwedeng i-abandon yun ni Board of Directors or Board of Trustees. Okay, why? Maybe because merong mga prejudice na third parties or creditors, corporate creditors. So they can always decide or counteract the decision of the stockholders in this instance alone. Okay? Kasi generally, the Board of Directors with regards to sale of all or substantially all, dapat lang yan, mag-propose lang sila to be ratified by the stockholders. But here, in this instance, they can abandon the decision of the stockholders to sell, lease, exchange, mortgage, pledge, or dispose of other properties and assets. Take note, nothing in this section is intended to restrict the power of any corporation without the authorization by the stockholders or members to sell, lease, exchange, mortgage, pledge, or otherwise dispose of any of its properties and assets. If the same is necessary in the usual and regular course of business of the corporation, or if the proceeds of the sale or other disposition of such property and assets shall be appropriated for the conduct of its remaining business. Meaning, this is not a limitation to the power of the corporation. Okay? If kahit pa hindi, ang sabi niya dito, kahit pa hindi daw mag-authorize or mag-ratify ang stockholders or members, if kailangan na mabenta lahat or kailangan na i-dispose yung mga properties, okay, as part of the necessary, as part of the usual and regular course of business, or appropriate to conduct its remaining business, then the corporation through its board of directors can act validly intra vires. Ibig sabihin, valid yung corporate act kahit walang ratification ng stockholders, basta necessary in the usual and regular course of the business and necessary for the conduct of its remaining business. Tapos tayo nun sa power to sell all or substantially all assets. Power to acquire own shares. Okay? Provided that the corporation has unrestricted retained earnings in its books to cover the shares to be purchased or acquired. Tandaan, ang sabi dito, provided that the corporation has unrestricted retained earnings. Meaning, it cannot acquire its own shares if it does not have unrestricted retained earnings. So yun yung pinaka-condition. It must have unrestricted retained earnings. Okay? Why? Why does the corporation acquire its own shares? Bakit yun? In-issue niya na sa stockholders. bibilhin niya ulit sa stockholders. Bakit kaya? Ito yung 3 reasons. Number 1, to eliminate fractional shares arising out of stock dividends. Maybe there are stock dividends issued by the corporation, and because of such issuances of stock dividends, nagkaroon ng fractional shares. That's the time that the corporation can acquire its own shares, provided that it has unrestricted retained earnings. Okay. Second, to collect or compromise an indebtedness to the corporation arising out of unpaid subscription in a delinquency sale, and to purchase delinquent shares sold during said sale. Diba? To collect or compromise an indebtedness to the corporation. If there is a delinquent stock, diba? Unpaid yung subscription. Okay? The corporation can just buy the issued shares para wala nang share yung delinquent shareholder, di ba? That's the instance wherein the corporation can acquire its own shares provided that it has unrestricted retained earnings. Last one, to pay dissenting or withdrawing stockholders entitled to payment for their shares under the provision of this code, precisely talking about appraisal right or right of appraisal. Di ba sabi natin kanina, appraisal right is the right of the stockholder who dissents or disagrees with the corporate act can sell his shares for a fair market value. Okay? The corporation can acquire the shares of that stockholder. Okay? They can pay dissenting or withdrawing stockholders entitled to payment for their shares. Yan yung appraisal right. Next, the power to invest corporate funds in another corporation or business or for any other purpose. Just like a natural person, di ba? The power to invest in corporate funds in another corporation or in any other business. Can engage to joint venture, partnership, di ba? Ganon din si corporation provided, okay, approved by the majority of the board of directors or trustees and ratified by the stockholders representing at least 2/3 of the outstanding capital stock or 2/3 of the members. Tandaan, dapat dalawa. Ibig sabihin, i-approve ni BOD, majority, and ratified by stockholders 2/3. Okay? Since meron na namang ratification, babalik na naman tayo sa written notice rule. So, parehas din sa mga discuss natin kanina. Okay? Same thing, meron ding right yung stockholder na mag-exercise ng appraisal right if hindi siya agree sa decision ng corporation na mag-invest sa other corporation. Provided, however, that where the investment by the corporation is reasonably necessary to accomplish its primary purpose as stated in the articles of incorporation, the approval of the stockholders. Diba? Just like yung na-mention ko kanina. Saan na yun? Dito. Kapag nagbenta yung corporation ng all or substantially all, kailangan ng authority ng BOD ratified by the stockholders. Kung hindi, invalid yung act. Pero dito kasi, necessary in the usual and regular course of business, necessary to conduct its remaining business, kaya kahit walang ratification si stockholders, pwede. Dito naman, sa power to invest, if necessary to accomplish its purpose, kahit hindi ma-approve ng stockholders. Okay? Basta maipakita ng board of directors or board of trustees that that investment of corporate funds to other corporations or to other business is necessary to accomplish your purpose, then hindi mo na kailangan ng approval ng stockholders para na kasi siyang normal corporate act ng corporation. Yung mga sinabi natin na tusu, bisod, gano'n. Magiging gano'n ang labas niya. Kaya hindi na kailangan ng approval ng stockholders. Maganda ko. Wait. Ayan na. Okay? The next power of the corporation to declare dividends. Of course, we have stockholders, we have investors. Of course, some stockholders, they want dividends. Diba? The board of directors of stock corporation may declare dividends. Take note of the word may. May. Pwedeng oo, pwedeng magde-declare, pwedeng hindi. So, may declare dividends out of the unrestricted retained earnings. Take note, kung merong unrestricted retained earnings ang corporation, pwede siyang mag-declare ng dividends. Pero kung walang unrestricted retained earnings, walang dividends na i-expect dapat ang stockholders. Diba? Why? Because yung dividends na i-distribute ni corporation sa kanyang stockholders, kukunin niya yun sa unrestricted retained earnings. Ngayon, kung walang unrestricted retained earnings, wala siyang ma-declare na dividends. Okay? These dividends shall be payable either in cash, property, or in the form of stock dividends to all stockholders on the basis of outstanding stock held by them. Is payment of dividend a matter of right? Diba? Just like what I've discussed here. Dapat dyan pa lang ma-determine nyo na kung matter of right siya or hindi. Diba? Kung meron siya, kung walang unrestricted retained earnings, mapilit mo ba yung corporation na mag-issue ng dividend? Hindi, diba? So what is the answer? Power to declare dividends. Provided that any cash dividends due on delinquent stock shall first be applied to the unpaid balance on the subscription plus costs and expenses. Diyan muna tayo sa una. Okay? If ang declaration ng board of directors or board of directors is to issue cash dividends. Okay? Kung merong delinquent stockholders, okay, hindi na mag-issue ng cash dividends. Why? Because instead na mag-issue ng cash dividends, yung delinquent stockholders na yun, o yung delinquent stock na yun, i-apply na lang yung supposedly ma-issue na cash dividend dun sa unpaid balance nung subscription nung stockholder. Diba? Kasi nga, since delinquent stock yan, hindi pa nababayaran yung subscription, i-apply mo na lang dun yung sanang cash dividend sa ma-receive niya. Para wala nang utang sa corporation yung stockholder. Kung stock dividend naman at merong delinquent stockholder, hindi bibigay yung stock dividends. Why? Because meron pa siyang utang. May delinquent stockholder nga siya eh. Kapag nabayaran niya yung buong subscription, kapag fully paid yung buong subscription, doon lang pwedeng i-release yung stock dividend sa kanya. Ba, swerte mo naman kung hindi ka pa fully paid sa subscription mo, pero nakuha mo na lahat ng dividends, di ba? So this is measure to protect the corporation against delinquent stockholders, di ba? Applying the principle of trust fund doctrine, di ba? Dapat bayaran nila yung subscription nila muna. Speaking of cash dividends and stock dividends, ito yung difference nila. When we talk about cash dividends, it is part of the general fund. Why? Because it's cash. Doon mo siya kukunin saan? Sa unrestricted retained earnings. If stock dividend siya, it's part of the capital. Why? Because your stock dividends, kukunin mo din siya sa capital stock mo. Diba? Cash dividends, there is a cash outlay, while stock dividends, there is none. Okay? With regards to cash dividends, hindi siya pwedeng habulin ng corporate creditors. Why? Because that's the share in the profit of the stockholders. Hindi pwedeng habulin yan ng corporate creditors. But with regards to stock dividends, stock yan eh, ni-issue ng corporation. that can be levied by the corporate creditors. Okay? Since, sabi natin sa una, part siya ng capital. Okay? Cash dividends declared by the majority of the quorum of the board of directors. So, kung mag-i-issue ng cash dividends, ang kailangan lang is majority ng board of directors. Wala lang ratification. While, kapag stock dividends ang dineclare, after the majority of the quorum of the board of directors, kailangan pa yang i-ratify ng 2/3 of the stockholders holding outstanding capital stock. Okay? So yung sa cash dividends, board of directors lang magde-decide, okay na. Stock dividends, kailangan ng ratification ng stockholders. Okay? Cash dividends will not increase the capital, but stock dividends will increase the capital. Okay? The declaration of cash dividends creates a debt from the corporation to each of its stockholders precisely. Kasi nga, ang sabi mo, ang gagawin dyan, kung mag-declare ng cash dividends, ibig sabihin si corporation, babayaran niya si stockholders. So, there's a debt created on the part of the corporation. Kapag stock dividends naman, walang debt na makikreate. Why? Because you are going to issue stock dividends. You are going to issue capital. Okay? Provided further that no stock dividend, yun sabi ko kanina, di ba? That kapag stock dividend ang dineclare, hindi lang approval ng board of directors, kailangan din ng ratification ng stockholders representing 2/3 of the outstanding capital stock. Okay? And then, since before we proceed to the continuation of this provision, we have to define the terms. When we say retained earnings, these are accumulated profits realized out of normal and continuous operations of the corporations after deducting therefrom distribution to stockholders and transfer to capital or other accounts. When we talk about unrestricted retained earnings, ito yung kailangan mo bago ka mag-declare ng dividends. Ito rin yung kailangan mo, yung sinabi ko kanina, bago mag-acquire ng share, ng own share si corporation. Unrestricted retained earnings are retained earnings which have not been reserved or set aside by the board of directors for some corporate purpose. Kumbaga, general fund siya. Diba? Kaya yung kapag merong laman yan, yung unrestricted retained earnings mo, ibig sabihin, pwede mo siyang i-distribute sa stockholders mo para ma-realize naman nila yung mga profits para makapag-share naman sila sa profits ng corporation. Only if merong unrestricted retained earnings. Dividends, these are corporate profits set aside, declared, and ordered to be paid by the directors for distribution among stockholders at a fixed time. So, dividends are not rights. Or right to a dividend mali. Wala tayong tinatawag na dividend as a matter of right. Okay? Saka lang magkakaroon ng right sa dividend kapag it has already been declared and ordered by the board of directors to be distributed. Yan, makikita mo yan sa board resolution ng board of directors and board of directors. So, hindi siya right to dividends. Okay? Diba? Kasi nga, ang pag-declared lang naman ng dividends is nakadepende kung meron kang unrestricted retained earnings. So, kung walang dividends. Kahit pa meron, kung hindi naman nag-declare si board of directors ng dividend distribution, wala din. Okay? Pero kapag nag-declare siya at nag-order na siya for distribution to stockholders, yun na, may right ka na dun. Okay? Stock corporations are prohibited from retaining surplus profits in excess of 100% of their paid-in capital stock. Meaning, stock corporations, hindi nila pwedeng i-withhold lahat ng profits nila. Okay? They can only withhold such profits equivalent to 100% of their paid-in capital stock. Any excess niyan, dapat nilang i-distribute. Except, kailan lang nila pwedeng i-withhold yan? Yung surplus profits na yan. Kapag merong corporate expansion, ibig sabihin meron silang expected na large capital outlay or expense. Kaya wini-withheld nila yung surplus profits. Okay, dun pwede, justifiable. Pero kung wala ka namang program or projects na for corporate expansion, dapat hindi mo i-withheld yung surplus profits in excess of 100% of the paid-in capital stock. Dapat yung excess dun, either i-declare mo yan sa stockholders mo. Or, when the corporation is prohibited under any loan agreement with financial institutions or creditors, whether local or foreign, from declaring dividends without their consent, meaning without the consent of the creditors or the financial institution, hindi ka pwedeng mag-declare ng dividends. May ganun. Okay? Kapag prohibited sa contract or sa loan agreement mo with your creditors na bawal kang mag-declare ng dividends without their consent, hindi pwede. Why? Because you may be prejudicing the rights of the third persons or creditors. Diba? Kung meron kang surplus profits exceeding 100% of the paid-in capital stock at dineclare mo lahat yun as dividends, the tendency is baka walang mahabol later on si creditors mo ng corporation, di ba? And kapag cash dividend yan, di ba? Hindi na mahabol yan ng creditors. Kaya lang dyan, basta merong loan agreement na sinasabi na hindi pwede mag-declare si corporation unless merong consent ang creditors, then pwedeng mag-withheld si corporation. When it can be clearly shown that such retention is necessary under special circumstances, such as when there is a need for special reserve for probable contingencies. Diba? Parang same lang siya dun sa first reason. As long as there is a reason for you to retain surplus profits in excess of 100% of the paid-in capital stock, okay, you can withhold or you can withhold it as a corporation. Okay, wala kang obligation na i-distribute yun. Basta merong basta necessary for special circumstances. Okay? So, recap. Kapag meron kang surplus profit in excess of 100% of the total paid-in capital stock, ibig sabihin, di ba, kunwari, yung amount ng paid-in capital stock is 1 million, for example, 1 million yung total paid-in capital stock. And meron kang surplus profits na 1.5 million. Okay? You can retain up to 1 million kasi yun yung 100%. Pero yung 500,000 hindi pwedeng i-retain ni stock corporation. Pwede niya lang i-retain yung 500,000 if merong number 1, corporate expansion project, merong loan agreement providing that the corporation cannot declare dividends without consent of the creditors, or necessary under special circumstances. So, yun yung recap. And then, malapit na. Power to enter into a management contract. What is this management contract? Under this instance, dalawang corporation ang involved. Ito yung instance na Corporation A allows Corporation B to control its operations, ganun, or services. Ganun ang management contract. Allows Corporation B to manage the operations, the services, the administration of the corporation. Yun ang management contract. Dapat dito, same as, hindi siya same. Bakit? Why? Tignan mo. It must be approved by the board of directors. Tama. Same siya dun sa unang previous na example natin. Pero, the stockholders owning at least majority of the capital stock or at least majority of the members of non-stock of both the managing and the managed corporation at the meeting duly called for the purpose. If maalala nyo earlier, yung laging votation, yung laging ratification ng stockholders is 2/3 of the outstanding capital stock. Ngayon, kapag entering into a management contract, hindi 2/3. Majority, meaning 50% plus 1. Majority nino? Majority ng stockholders of the capital stock or majority ng members of both the managing and the managed corporation. Di ba sabi ko kanina dito, dalawang corporation, Corporation A, Corporation B. Si Corporation A, pinapamanage niya kay Corporation B. Dapat approval ng both board of directors and both majority of stockholders or members. Yun yung entering into a management contract. Provided that where stockholder, ito, kapag merong interlocking stockholder at interlocking director. Kailan magkakaroon ng interlocking stockholder? Where the stockholders representing the same interests of both the managing and managed corporation own or control more than 1/3 of the total outstanding capital stock entitled to vote of the managing corporation. Yun muna, interlocking stockholders. Di ba, meron si Corporation A, si Corporation B. Ang sinasabi sa interlocking stockholders, there are stockholders in Corporation A who are also stockholders in Corporation B owning more than 1/3 of the total outstanding capital stock entitled to vote of the managing corporation. So, dapat yung stockholder sa Corporation A, stockholder din sa Corporation B, owning 1/3 dun sa managing corporation. Ganun din sa interlocking directors. Ibig sabihin naman dito sa interlocking directors, majority of the members of the board of directors. Ibig sabihin, majority of the board of directors in Corporation A is also the majority of the board of directors in Corporation B. So, merong interlocking. Meaning, kasi kapag ganyan, parang same control, parang parehas lang sila di ba? Kasi majority ng board of directors ng Corporation A is na kay Corporation B. Ang iniiwasan kasi dyan is fraud. Anong gagawin? The management contract must be approved by the stockholders of the managed corporation owning at least 2/3 of the total outstanding capital stock or 2/3 of the members in a non-stock corporation. So when that happens, when there are interlocking stockholders or interlocking directors in a management contract between two corporations, dapat approved by the stockholders of the managed corporation owning at least 2/3 of the capital of the outstanding capital stock or 2/3 of the members thereof in a non-stock corporation. This shall apply to any contract whereby a corporation undertakes to manage. Ito na yung meaning ng management contract. Management contract is a contract whereby a corporation undertakes to manage or operate all or substantially all of the business of another corporation, di ba? Kaya dalawang corporation. Whether such contracts are called service contracts, operating agreements, or otherwise. Okay, yun yung management contract. Provided, however, that such service contracts or operating agreements which relate to exploration, development, exploitation, or utilization of natural resources may be entered into for such period as may be provided by the pertinent laws or regulations. Take note, under dito sa provision na provided, sabi niya, basta yung agreement is with regards to exploration, development, exploitation ng natural resources. Kasi hindi basta-basta yan. Okay, dapat depende din siya sa period na grant. Kasi usually yan, may mga licensing agreements subject to further regulations by other government agencies. So, limited din yung term niya. Why? Because the term of a management contract shall not be longer than 5 years for any one term. Okay? Sa isang term, dapat hindi more than 5 years. Pwedeng 5 years, basta not more than 5 years. Last slide. No corporation under ultra vires acts of corporation. Yung kanina, diniscuss natin lahat ng powers ng corporation. Ito naman, ultra vires, ibig sabihin, this is not the power of the corporation. These are acts, ultra vires acts. These are acts by the corporation that are outside its powers. Meaning, kapag ginawa ito ni corporation, hindi valid yung corporate action. No corporation shall possess or exercise corporate powers other than those conferred by law or articles of incorporation, and except as necessary or incidental to the exercise of the powers conferred. Kaya importante yung ulit-ulit na ibalik nyo sa isip nyo na ang corporation, ang power niya lang expressly conferred by law or the articles of incorporation, and those that are implied or incidental to its purpose or powers. Yun lang. Okay? Yun lang ang powers ng corporation. Any other powers or any other acts na ginawa ng corporation, ultra vires. Ultra vires sila. Okay? So that ends our topic.